Well, it is right at 11 o'clock, so we'll go ahead and get started. And we are recording this, so we will send this to everyone who signed up, and we'll put it on my YouTube page as well. So if you have questions, you can go back and look at it, or feel free to email or call me. But today we're just going to be discussing Probate 101, a little information about me if you haven't had one of my webinars before. I'm a graduate of the University of South Carolina and the School of Law, and I practice in estate planning, Medicaid planning, probate, and business planning. So our kind of outline of topics for today is what is probate and some basic terms we're going to hear during the probate process. What is the probate process? Some common problems people have when you need to see an attorney, and some kind of tips for probate avoidance. So probate is the process by which assets, we have a few more people, I'm going to admit them real quick. Okay, so we've got some new participants, so we'll just go ahead and kind of go back over probate. Probate is the process by which assets are transferred from the decedent, that's the deceased individual, to his or her heirs or devisees. Probate is approximately a year-long process here in South Carolina. It's 8 months, but by the time you open it and everything, it's usually about a year. The reason for the long probate process is we have to do things like give notice to creditors, and they get an 8-month period, and we'll talk a little bit more about that in a second. But pretty much probate is managed by the probate court, and it is just the process by how we're going to take the decedent's assets, which are probate assets, and distribute those to individuals who either are their heirs or devisees. So what is probate property? That is a big question we have a lot. It is assets that go through probate are assets that are individually owned by the decedent with no beneficiary designation. For example, if an individual owns a bank account that's solely in their name that doesn't have anything payable on death, that's going to go through probate. If you own a home in your name, it's going to go through probate. If you own a home with your spouse, but you're not listed as joint tenants with right of survivorship, that's also going to go through probate. So if you are just your husband and wife, and it's just Mr. and Mrs. John Doe on the deed, then that means it's going to go through probate. It has to have joint tenants with right of survivorship, not as tenants in common, in order to avoid probate. The next thing we can talk about is vehicles. A lot of times you own those individually. If you do so, they are going to go through probate. Retirement accounts, your IRAs, 401ks, they will go through probate if you don't have a beneficiary listed on them. And personal property will go through probate if you do not have a beneficiary on them, or do not have them in a trust or some type of other way. So some basic probate info before you have to get started with probate. So when a person dies, probate is going to be in the county in which the decedent lived at the time of their death. So you're going to have to start probate there. If you own property in multiple counties, you may have to have probate in multiple counties for that different piece of property if it is owned solely by you. So for example, if you own a home here in Spartanburg County, but maybe you have a beach house down at Myrtle Beach, you're going to have to probate here in Spartanburg and also down at the beach because of that real estate being there, and you have to have proper documentation. So a lot of times people use the term personal representative executor. It is the same term. This is the person who just handles the probate process and works with the probate court to handle probate administration. Some more basic probate terms that you're going to see if you're going through probate court: intestate. So when you see this term, it means the individual died without a will. So if you die intestate, you are passing away without a will. Heirs are who inherit by law. So these are people that you didn't have a will, and it's your family that is going to inherit through the Uniform Probate Code on intestacy. So this means your heirs are typically your spouse, your children, Could be your parents, your siblings. It kind of depends what your situation is when you die, but you don't have heirs until you die. Devisees is people who are left in the will to get your assets. So if you have a will, those are devisees. Decedent is the person who died that's you're going through their probate process. One thing with intestacy, so it's by the Uniform Probate Code. And so with intestacy, it means that if a person passes away without a will, but they're married and have children, half of their assets will go to their children and half will go to their spouse. A lot of people don't realize it doesn't automatically all go to the spouse. So it's important that you know this. So you want to have a will to usually correct that situation. A will is what is taken to probate that determines how your assets are being distributed. If you don't have a will, like we said, it's through the Uniform Probate Code through the laws of intestacy. If real property is going through the probate process, you're going to hear mentions of a deed of distribution. A deed of distribution is the deed that is used to pass the probate real property from the decedent to the devisees or heirs. It's like a normal deed. You have to have the legal description. It still has to be recorded with the Register of Deeds, and then you'll record it with the probate court as well. So it has to be recorded in both places. And the personal representative is who is going to sign the deed on behalf of the decedent. So now we're kind of going to get into the actual probate process since we've went over some terms with it. So the first thing you need when you're going to probate is a death certificate. So usually when a person passes away, it could take, a week to 2 weeks to get this death certificate, and you can't do a whole lot until you have that. Step 2 is you're going to need to look and locate the will. So if a person has a will, you're going to want to locate it. You're going to want to think about if they've never told you where it is. Could it possibly be in a safe deposit box? Is it in their house in a safe? And if it is in a safe deposit box and you are not listed on that safe deposit box, the bank isn't going to let you in just with the death certificate. You're going to have to go to probate first and see if they will give you paperwork just limited in scope so you can get in that safe deposit box and see if there's a will. And so the big thing to look for in a will, first of all, is who is the personal representative? Who is listed that is going to handle probate? If you know they don't have a will and you can't find one, the question is, who is the personal representative going to be? It is usually the next of kin. So if it is a married couple, usually the spouse will be the personal representative. If the spouse doesn't want to be it, she can elect not to be the personal representative, and maybe one of the children want to take over. If there's no spouse, it could go to the children, and that could be a decision between them if multiples want to serve or just one. But after you know you have the will or don't have the will, and we figured out the personal representative, you're going to need to call your local probate office, the one where the decedent passed away, to schedule an appointment. So you're going to need an appointment in almost every probate court now, especially during COVID. But even before, they usually want to schedule an appointment so they will have time to talk with you and go over everything. So at that point, we're going to begin the probate process, which is full of paperwork that you're going to have to work through and submit to the court, and the court will handle the probate process with you. So now we're going to talk about kind of the probate paperwork you are going to need to file during this probate process. So the first thing is the informal application for probate. Most people will file an informal application for probate. Most people are not going to file a formal application. Formal means the judge is kind of going to oversee everything. Informal means you're going to work with the clerk just to make sure the assets are properly distributed and you do the proper probate paperwork. And it's just you handling everything as the PR. But on this application, we're going to need the decedent's information, their place of residence. We're going to need their death date. You're going to have to list their heirs at law, and you're going to need to list the devisees in a will. If you are wanting to be the personal representative, you're the one that needs to fill out this paperwork, and you're going to need to give your personal information as well. And then from this paperwork, the court will then appoint a personal representative. When you go in and open probate, we then have to do a notice to creditors with the local newspaper in that county. Typically, most courts will file this for you. I know Spartanburg will file it for you. You just pay the fee to them. Union County will as well. I'm thinking Greenville does, but I'm not 100% sure on that. But once it's filed, it has to run 3 times in the newspaper, and it's 8 months for the creditor period from the date it runs for creditors to make a claim against the estate, or 1 year from the date of death. You're also going to need to send notice to heirs in the devisee, so they know that they were listed in the will. So they have a right to get notice of what's happening in probate and to know what is going on because they are beneficiaries of the estate. So you've done all this work, and during this time frame, you're going to be working on what's known as the inventory and appraisement. And this is probably the hardest part of the probate process if it's just a simple probate. It is due 90 days after opening probate. This is where you're going to have to list all of the decedent's probate assets. So you're going to need to know where their bank accounts are, if there's real property, if there's any life insurance or any retirement benefits that are going to run through the estate. You're going to need to have these listed on the inventory and appraisement, and you're going to need to identify them. So, for example, with the vehicle, you would want to say it's a 2010 Camry, and then the value of it. So on this inventory and appraisement, you're going to have to list the value of the assets. And it's important to make sure you get an accurate value of these assets. So for a house, sometimes if an individual bought it, 60 years ago, and the value of it when they bought it was really low and it's really increased in value, you may need to look at having an appraisal done, or you want to have a realtor who has knowledge of it give you a report of the fair market value, because you want to make sure you list an accurate value of the house so the beneficiaries get that step up in basis for tax purposes. But once you do all this, the fee is based on the probate assets. So it is a percentage of the probate assets makes the fee. Usually to start probate, you're just going to pay a small fee, and then they'll give you the fee based on the inventory and appraisement. So after you've done all this, you're going to do disbursement of the assets, and you're going to look at it through, if there was a will, you're going to properly disperse it by the way the will was stated. If they're intestate, you're going to make sure you do it by the way the Uniform Probate Code. So this includes doing things like a deed of distribution for real property. You're going to have to go to the DMV to file for titles for motor vehicles, so that way you can properly convey those out of the state. You're going to file a proposal for distribution with the probate court, so that way they know how the assets are being distributed and making sure you're properly doing it. So once you've done the disbursements, you need to file a final accounting that details how the probate assets were spent and how you spent money. For instance, during probate, you may have fees that you're going to have to pay as the personal representative out of the estate account to be able to pay the bills that this person has. So for the estate account, you want to open that when you start probate. Typically, if there's going to be liquid assets you need to have handled with the estate. And you do this with the bank and getting an EIN number for the account. And with that account, you want to make sure you keep everything properly filed, have an Excel spreadsheet, know what you're doing, because you are going to have to turn all this into the probate court. So if you had to pay taxes, if you had to pay insurance on real property, you want to keep a list on this, so when you fill out that final accounting, they know what's happened to all the assets, and there's no issues with heirs saying you mismanaged anything as the PR. So it's very important to keep good records so you'll be able to do this final accounting. You have to send notice of a right to demand a hearing to the heirs. So this is if they believe something has been done wrong by you, or they're not sure and they need more information, they can request a hearing on everything. If everything has gone smoothly, you do an application for settlement, and the PR is released of their liability. So overall, probate is very form driven, and you're going to have very good records to make sure you've done everything properly. If you are the PR, keep good records of any estate account you have. Make sure you properly put the assets in there. Do not put estate assets into your personal account. For instance, if you have a bank account that was owned in this person's individual name, you take the money from that account and put it in the estate account. Do not commingle it with your own assets. That's how you get in trouble for a breach of fiduciary duty, because as a PR, you do have a fiduciary obligation to the beneficiaries. So that's just a quick overview of the probate process and how it works. So some common probate problems that a lot of people see are dealing with creditors' claims. So it's up to the personal representative to allow or disallow each claim. When a decedent dies, that's why they put that notice in the newspaper, is so a creditor can make a claim. There are assets that maybe a creditor has a secure lien on, like a mortgage. That doesn't go away when a person dies because it's attached to the property. So you're going to need to continue to pay those bills, or there could be a foreclosure. Same thing with taxes. If you don't pay those, the assets could go to a tax sale. Where there's more questionable is if, was this a real creditor claim? Did this person really owe this money? Is there liquid in the estate to pay this? For instance, the funeral home is going to file typically a claim if you don't pay them with the probate court for their fees. That is an allowable claim most of the time because they gave you services. So they have a right to get paid back their money. If there's no liquid in the estate, the creditor could put a lien on the real property, which has happened in situations where there was no liquid. You go to sell the property, and that's how that creditor would get repaid, is through the selling of that property typically. Real property issues is kind of another big issue that we see in probate. If you don't have a will, you're going to have to ask the judge to be able to sell assets, real property assets in probate. So I've had to do this for a lot of clients. Their parent passed away without a will. They can't afford, or they don't want to be paying to keep up the mortgage, the taxes, and they want to get rid of this property as soon as possible. Typically, you are allowed to sell it, but you have to submit that petition to the probate court. Each probate court is different on how they handle it. Sometimes you have to have a hearing in person. Sometimes they'll accept affidavits. And if there's any contest from other heirs about the selling of this property, you are going to have a hearing in the court process. But if you have a will, you can go ahead and give your PR permission to sell property, real property, so they don't have to go through a hearing with the probate judge. Some less common issues that we see with probate is probate problems such as will contests. And that's where we're going to look, was this will properly executed? You have to have 2 disinterested witnesses for a will in South Carolina. So you want to make sure it's properly done. Even if it was properly executed, was there duress or undue influence? And I will say this is an area that is getting a lot of attention right now, and is elder abuse. And we're seeing a lot of claims nationally where elderly individuals are being taken advantage of and changing their wills, possibly by a caretaker or a family member that hasn't been in contact. So that is a big area of litigation right now. Another area we see a decent amount is personal representative removal. So if you're a beneficiary and you think the PR has not properly handled the estate, maybe they've commingled the assets, they're not properly distributing the assets. So with that, they're breaching their fiduciary duty, and we may need to bring a claim in probate court to have them removed. And at that point, we may look to having a personal representative appointed that works for a bank or works for a trust company. So it's a corporate responsibility, and we can make the estate management a little better for the family at that point. So in all this, when do you need an attorney? So the probate process sometimes can be really simple, and you work with the probate court and you don't need an attorney, and you just work with the clerks there. There's times where I think it may be more important, like drafting a deed of distribution, since you want to make sure that's done properly for the real property, so there's no issues, 20 years down the road and you have to look at a quiet title issue. I think anytime a petition is required, that may be a time where attorneys are needed, such as elder abuse, removing a PR, petition to sell real property, or dealing with creditors' claims and you're not sure how to handle those. Sometimes in larger estates where it's a PR who is just an individual and not a corporate PR, they could be overwhelmed and not sure how to handle it. So that's the time they may want to look at having an attorney just walk them through the probate process. But that's kind of personal decisions there, but I do think there's times it's more helpful than others. So some tips for avoiding probate. So what's going to go through probate, like we mentioned before, is assets owned solely by the decedent. So some ways to make things pass out of probate is things like joint tenants on a bank account. So for a husband and wife, if you bank together, that way you can, if one passes away, the spouse automatically has control of the bank account. Or you can make bank accounts payable on death, so that way your family member or friend or whoever you leave your assets to submits the death certificate to the bank, and they'll automatically give you a check or roll your account over. Real estate is one of the biggest things that go through probate. There's a few ways to keep it out of probate. Joint tenants with right of survivorship for spouses. You could possibly have it owned as a life estate, and that means you own it for your life, and then it goes to the beneficiary of that at your death. There's some pros to that is it can be useful, so it avoids probate, but some cons are you can't sell that property anymore without those beneficiaries signing off on it too. And there could be implications as how much value you get out from the sale using life estate tables to see maybe you're not going to get the full value of their house. So I think that's an area you really want to talk to an attorney about is, should I do a life estate or should I not? A way to keep it out of probate is using a trust as an estate planning tool. So we can fund that with life estate, with real estate, bank accounts, vehicles, pretty much any of your assets can be funded into the trust. I do caution on using 401ks, IRAs running through trust, but that is a personal preference we would talk about. And making sure you have beneficiaries on your life insurance, your 401ks, your IRAs. Because if you have beneficiaries, it's going to pass outside of probate to them directly. The same way with the bank account, you just submit a death certificate and that gets the process rolling for you. So that's some quick tips that are easy to help you avoid the probate process. So a lot of questions I get from my clients are, should I avoid probate? I think it is pretty much your personal choice. There's no right or wrong way to do it. An individual just needs to weigh the pros and cons of it. Some cons are it's a longer process, you're paying fees to the probate court, and everything is public record. So if I wanted to go look at what you inherited from your grandmother, if it went through probate, I can go to the probate court and pull the records up. Not that I think many people tend to do that, but it is a public record and people could view it. Some pros, you can still direct how you want your assets to be distributed with a will, and that is cheaper than a trust. Trust can be expensive to set up. It's very form driven for probate, and most of the forms are online. If you go to sccourts.org and do a search for forms, all the probate forms are there, and a lot of local counties have their own forms that you can find on their website. So it's not the worst process, but a lot of people do want to avoid it due to the time frame it takes up and it being the public record, and you do pay fees for it. So I think it's just your pros and cons on what's important to you, and if you want it to be through probate or outside of probate, we can work on that, but it's just your personal preference. There's no right or wrong way. So just some kind of final thoughts before I have a few minutes for any questions if anybody has any. Probate is distributing assets of a decedent, form-driven process, and making sure you properly handle the estates. You can make your assets pass outside of probate if desired, and you may need an attorney during certain points of the process. Overall, it is an easier process if you have a will in place so it's not intestate, and making sure that you know who can handle the stress of being a personal representative when you leave somebody that burden. It's not that it is hard, but it is time consuming and it does take a lot of effort. So always talk to your family members before you decide to leave them as your PR or your trustee, and they may not want that responsibility. So that's one thing I always caution people to do. But I wanted to finish up pretty quick so we could have a few minutes for questions, or if there's not any questions, you can feel free to email me or give me a call and we can talk about your problems. But I do think probate, a lot of people are scared of it, and there's no reason to be scared, but it does have a lot of technicalities, and sometimes it's easier on your family to avoid it, but it's just personal preference for you. So if anybody has a question, feel free to chat it to me or unmute yourself and ask.
Hi, Lauren. This is Benita. How are you?
Good. How are you? Thanks for joining.
Can you hear me?
I can hear you.
Yes, ma'am. I would not have missed it. Thank you. I had someone in my office. I missed like the first 10 minutes. You used PR quite frequently before I was able to get on and after I was able to get on. So I am wanting to know, what is that the acronym for, and is it the same thing as the executor of the will?
Yes, it is personal representative, and that's the term that's more commonly
Okay.
used now. But it is executor is the male term, executrix is the female term, but you can use them all kind of interchangeably. They all are the person handling the probate process. Any
Great, thank
other?
you.
You're welcome. Do you have any other questions since you missed a few minutes?
Now, I am just thinking with that on my mind right now. I do have a son at the age of 24, and then I have a young son who is 13. And so now I'm thinking if anything happens to me, you know, I wouldn't want that on my 24-year-old, but then I just, I can't really think of anyone that I could trust other, you know, that's family. So it's like, okay, I probably need to go outside of the family to do that. I do have a will currently, but it does need to be updated because I just recently purchased a property and done some other things, made a lot of other changes since my last will was done a couple of years ago. So I am,
What I was going to say is, yes,
what
I know
would you,
it's hard when you have a 24-year-old and then a minor child. Some of it is pretty much, do I want to have a family member handle it? And if you don't have a family member that's local, that's when you could look into things like a corporate personal representative. The downside of that is they are going to charge fees, but it does take a stress off your family, and they are well versed in doing it. So a lot of people that serve as corporate trustees or bankers, financial institutions, trust officers, sometimes an accountant, some attorneys will serve as PR. I don't do that. That's just not an area of work I like to handle, but some attorneys will. I like to do the drafting, not the serving as the PR, but I don't mind being an attorney representative for the PR. But I think that's kind of an option, or even if you have a family member that's not here, you can still leave them as PR, and they can always hire counsel here to help them kind of work through the process. But it is hard when you don't have a person that you want to give that burden to. So that's why I always say, let's think about the different options, maybe family that's not here or looking at a corporate trustee. And with having minor children, you can always set up a trust inside of your will for the benefit of minor children. So that way they don't inherit when they're 13 years old. You could have a trust that that person that's your PR could handle. And then when they're 21 is when they could inherit flat out. But during that time, use it for health, education, wellness, maintenance, and support. I did get a
so
question.
I have right now
Go ahead.
I'm sorry.
You're fine. Go ahead.
I have a testamentary trust. I have a testamentary trust is what my will do, I guess, after I pass, where it will, so the money will not be going directly through probate, but I guess I just need to, because I just purchased a home, make some changes there
Yeah,
as well, so that's included in my will.
Yeah, for sure. And a testamentary trust, just so everybody understands, is a trust that's created inside your will. So it's not a freestanding trust. It is a trust created in the will, and it won't be created until you pass away and the assets are going through probate. But you still can have the benefits of a trust as far as allowing children not to inherit or to protect those children from if they get divorced or things like that. So that's one thing that is a good thing to have in a will if you're worried about minor children, is that testamentary trust for minors. One person did message and say, can you email the PowerPoint? So what I'll do is when this is over, everybody will get a copy of this webinar, so you'll have the PowerPoint with you. And then another question, do assets in a trust automatically pass to the beneficiary when the owner passes, or is the paperwork involved? So there is with the trust going to be some paperwork involved. With real property, it's going to depend. Are you going to leave it in the trust? Or are you going to pull it out? So there'll have to be a deed. With bank accounts, if you're going to pull it out, you're going to just from being in the trust and the devisees or the beneficiary of the trust, you're going to have to do some paperwork with the bank, but it's not a process governed by the probate court. It's just governed by what's in the trust. So it can happen a lot quicker usually. It's kind of a benefit of a trust. Kind of pros and cons of trust is something that you have to weigh out because they are more expensive to create, but it can make it a lot easier in the long run. Do we have any other questions?
Lauren, I have a question really quickly. So you mentioned if someone dies without a will, that half goes to the spouse and then half to the children? What if they don't have a spouse or children? And or what if it's a blended family? How does that work? And they don't have a will.
Is a great question. So with if you die without a will, so the first with the Uniform Probate Code is half to spouse, half to children. If you don't have a spouse or you don't have children, so if you had if your spouse had predeceased and you had children, it's automatically going to go to the children. But you have neither, it's going to kind of keep branching out in your family tree. So if you have parents, it's going to go to them. If your parents have predeceased you, it's going to look to your siblings. If your siblings have predeceased you, it's going to go to their children. And then at a certain point, it's going to stop because we're going to get way too far out the family tree, and it's going to go to the state. It's called a sheet to the state. So if you don't have any family, pretty much, it's either going to go to some family you haven't talked to some distant third cousin that you don't want it to go to, or it's going to go to the state if you can't even find a relative. So for people in those situations, I always recommend having a will, and that may be, if you don't have family members that you want to inherit your assets, that may be the time that you want to think about looking at charities and looking at nonprofits, like for Lisa, looking at Wofford College, or Benita's at Upstate. So those are great places to leave your assets. So if you have no family, but if you don't have a will saying that, it's not going to go to anybody but way distant cousins or possibly the state. So it's really important for those people to have a will. Do we have any other questions?
Hey, Lauren, this is Anna Duffenbaugh, signed on as Cassie Reed. How are you?
Good. How are you?
Good. I'm going back to just a further explanation on the response that you gave to the person who typed in the question on trust and probate. So I understand with joints of right of survivorship, property is going to pass to the spouse. If it's a joint tenant in common and the client or the person has a trust, why does that go through probate, or does the trust override that if it's a joint tenant rather than a joint with rights of survivorship? Does that make sense, what I'm trying to say?
I think so. So with a trust, if you have real property, you're going to actually have to deed that property into the trust. So just because you have created a trust doesn't mean it's been funded. So you have to do a deed, and you're going to deed it to the trustees of the trust. The trust technically can't hold the property. It's always the trustee. So if you forget to do this, or it's something you bought new property and never did it, normally when I set up a trust, we go ahead and look at your real estate and we go ahead and move it. But you know, you may buy a new house and just forget about it. So if your tenants in common are joint tenants with right of survivorship, it's not going to pass the way of the trust. What'll happen is whatever is on the deed controls with real property. So if on the deed it says Mr. and Mrs. Jane Doe just Mr. and Mrs. Jane Doe, in South Carolina, your tenants in common. So your half of the house is going to pass through probate. And then you may have a pour over will, which then funnels it to the trust, but it will go through probate. If you have Mr. and Mrs. Jane Doe as joint tenants with right of survivorship, it automatically goes to the surviving spouse, but it doesn't go through the trust. So it's important if you set up a trust to make sure you properly funded it with that real estate and that you've done a deed, because what is on the deed is going to control for real property. Does that answer your question?
It does. Thank you very much.
Anybody else? I know probate is a confusing topic, and you hear a lot of your friends and family talk about the process. I just want everybody to have a basic kind of understanding of it.
Hey, Lauren. This
Yes.
is Christopher Chestnut. Can you hear me?
I can.
I want to go back to the part about the probate is carried out where the person passed away. I'm up in Landrum, so I have a lot of folks that might move to White Oak or Trine Estates or Laurel Woods, which is in Polk County, North Carolina. And so in the past, they've kind of had to file probate in North Carolina, and they might still own a house here, you know, in Spartanburg County or maybe Greenville County, kind of a little triangle up here with county lines. But I just had a client recently pass away, and they told them that even though the guy had been basically living in Columbus at the facility for probably 3 years, that they didn't need to do probate there, that they needed to do it in Spartanburg County
Sometimes
because he owned property. So is that,
so you're
is
going
that
to
a
have
state
to
line thing?
probate where you own real property. And so sometimes with nursing homes, you never change your domicile to the nursing home. You always keep it at your house. Some people do this because, looking at Medicaid, you want to make sure that you have an intent to go back to the house, so you're not changing your domicile. So that means you would probate where you were domiciled at the time of your death. So that would be South Carolina. But if you change that, or if you just bought a house in North Carolina and still own property in South Carolina, and you make North Carolina your primary residence, you're gonna have to probate in North Carolina and then do certified copies and come probate here in the county where there's real estate. But kind of nursing homes can kind of be different exceptions to the normal rule, because they may not have actually changed their residency and they're still actually a citizen of Spartanburg County. They're just living in a facility in North Carolina.
Okay, I just was basing my, hey, you might want to look out for this advice, because we had somebody that just got taken to the hospital one time, was there like 8 days, and they died, and they made them do probate there. Even though,
Yeah.
it was really weird. So 2 or 3 years later, this person had been basically hanging out there for 3 years, and they're like, no, you don't need to do it. So I didn't know if something had changed. It just seemed to be contradicting what they had told them.
It's kind of hard with those like nursing home and hospital situations. Those can be kind of special cases, but definitely if they're owning real estate in multiple places, you're definitely going to have to do a probate estate. You don't have to do the full probate if you own property in a second county, but you are going to have to send certified copies and do the deeds and everything like that. For instance, my husband's grandmother passed away. She had property. She lived in Union, has property in Chester. So there's probate in Union, and we're going to have to send the certified copy to Chester. And it works the same if it's somebody that's out of state as well. You just have to make sure you probate in both places to get that real property taken care of. And with that in mind, you do want to make sure you get real property taken care of, because probate only has jurisdiction for 10 years after the person passed away. And if you don't get real property taken care of, you might have to go to a quiet title action with the master in equity, which is a lot more work than probate.
Okay. Is there a way to avoid that? It's ancillary probate, right? That's what you're referring to. Can't you get, if you put it like in a living trust in other counties?
Yeah, so like if you have a trust and you fund it with your property, you can put property from South Carolina, North Carolina, wherever you want in this one trust, and that would avoid having to have multiple probates.
Okay.
I always recommend for people with property in different counties or different states, at that point a trust is probably worth it because of the hassle of the 2 different probates, and you're going to have to pay fees at both places.
Okay. All right. Thank you.
Does anybody else have a question?
Lauren, this is Courtney Fowler. Can you hear me?
I can.
I just have a real quick question. Do you know of any, I'm currently dealing with actually 2 probate situations, but with COVID, do you know if they're giving extensions? You talked about filing the paperwork within 90 days after the death. Well, that has been a nightmare for me because my dad was not organized, unfortunately. But do you know how I would, because he had a lot of things in his name or whatever. I am the only child, but what I'm running into is problems getting the proper information, from banks and things like that. I had to make appointments here, appointments there. Do you know who I would need to notify? It has actually been a little over 90 days now, so I'm getting a little concerned. I still don't have all the information available for them to submit that paperwork.
So with or without COVID, you can always request an extension for the inventory and appraisement. But during this COVID process, I imagine they're going to be a lot more generous in granting it because it is harder for everybody to get to the banks. And probate's not taking a lot of in-person appointments. So I would definitely say, go talk to your clerk, request an extension. And now if you mess up and you go ahead and file the inventory and appraisement, and not that you messed up, but that, a month later you see, oh, my dad actually had another bank account that I thought I'd got everything, you can file an updated inventory and appraisement too.
Okay, I appreciate that. Thank you.
Anybody else? Well, you are all more than welcome. My email is up there to send me an email with any questions or follow-ups, and we will send this presentation out to everybody that's registered. So you'll get the PowerPoint and you will get the information in here and the questions and everything. So that way, you know, later on you may have one of these questions. But it was great to have you all on here with me today. And in the future, if you need anything, feel free to give me a call. And I hope this was a help to everybody. But thank you all for joining.
Thank you.